I don't know you, but I love you, and you're brave, and you would have protested the Vietnam War and ended it. This is the modern equivalent to that. So thank you all.
We got you, Karen.
On a holiday, you should be at a beach, and you're here on a corner.
No way.
No way.
Wouldn't want to be anywhere else.
Can you win a trial with a KISS? A KISS is an acronym for Keep It Simple Stupid. In 1960, a naval engineer wanted designs for repairing warplanes to be simple, because in combat conditions, you do not have time to be messing about with complicated instructions. They needed it to be simple. And what's the first thing you do if you buy something that needs to be put together? If the instructions are complicated, what do? You might start to read them, and then after a few hours, you toss them aside and figure it out logically. Can you relate? Hello, legal-minded friends. I'm Karen Cole, and we will find out how this KISS concept plays a role when a jury is deciding a verdict on a case in just a bit. But first, some of you following the Karen Read case probably know Karen Read is accused of being criminally responsible for the death of her boyfriend, Officer John O'Keefe. Check out my playlist for a catch-up. After a very long 9-week trial and 5 days of jury deliberations, the jury failed to return a verdict. So the judge declared a mistrial, and the Commonwealth of Massachuetts said they intend to retry Karen Read. And the judge has scheduled a retrial date to start on the 27th of January 2025. So when they say intend, that doesn't mean that they will. We'll have to see if that happens. Now, I've seen some chatter on the internet that a retrial normally favors the prosecution, meaning that they normally win, and ultimately the defendant is found guilty. But is that a given? So I thought it would be interesting to follow a few trials that ended with a mistrial and see how their outcomes turned out after being retried. Some of the cases you may have heard of, and some maybe didn't get so much media coverage. So let's get started. The first trial up is Andrew Mitchell from Columbus, Ohio. He was a police officer accused of killing a woman after she, according to him, turned violent when he was arresting her. Let's have a listen to the news.
We're hearing from the family of Donna Castleberry after a mistrial was declared in the case related to her death. Former Columbus police officer Andrew Mitchell shot and killed Castleberry back in 2018. At the time, he was working as an undercover officer. He says he acted in self-defense.
After 2.5 days of deliberations, jurors told the judge that they were deadlocked. Well, yesterday afternoon, jurors told the judge at the time that they were at an impasse, with 7 saying Andrew Mitchell's actions were reasonable, 2 say it was unreasonable, and 3 were undecided. So earlier this afternoon, the jurors once again told the judge they couldn't decide. He gave them additional instructions to continue, and about an hour later, they came back and told the judge they could not come to a unanimous decision. And this has been an incredibly difficult couple of weeks on both families, who have sat through hours of testimony and video and audio evidence.
We're proud of the job that the prosecution did trying this case, and as a family, we're disappointed in the outcome.
Yeah, again, they're disappointed, but they respect the process. They know that those jurors tried the best that they could, and they have faith in the system.
So the defense says they plan on the case being retried. Mitzi Crisp, 10 TV News.
Lacey, thank you.
So what do you think happened at his retrial? Do you think he was found guilty or not guilty? Well, let's find out.
The first verdict, State of Ohio versus Andrew Kirkmichael, case number 19 CR 1662. We, the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of murder as charged in count 1 of the indictment signed this 18th day of April 2023 by each and every juror. Second verdict, State of Ohio versus Andrew Kirk Mitchell, 19 CR 1662. We, the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of voluntary manslaughter as charged in count 2 of the indictment, signed this 18th day of April 2023 by each and every juror. Do you guys want the jury pooled? No. All right, ladies and gentlemen, thank you. On behalf of the community, on behalf of the court, and on behalf of the parties, thank you so much for being responsible citizens and coming down here. You are now discharged from all admonitions and instructions. Thank you again.
So the next case up is Darcus Allen. It's very interesting, and let's just have a listen.
Prosecutors say Allen drove Clemens to and from a coffee shop where Clemens murdered the officers. Clemens, a felon, entered the shop and shot and killed Lakewood Police Sergeant Mark Renninger, Officer Greg Richards, Officer Tina Griswold, and Officer Ronald Owens as they prepped for a Sunday morning shift on November 29, 2009. Allen has said he did not know what Clemens was going to do and didn't know what occurred inside the coffee shop until they were driving away. His first trial ended in a mistrial in 2015 when a judge declared there were flaws in a trial.
So what do you think happened in his second trial?
The judge has declared a second mistrial against Darcus Allen.
Allen was the getaway driver for the man who killed 4 Lakewood officers in a coffee shop. This was in 2009. Fox 13's Dan Griffin is in the newsroom with what happened in that courtroom and what we can expect to happen next. Dan?
Hey, good morning to you. Yes, so jurors deliberated for more than 6 days and could not make a decision when it came to murder charges against Darcus Allen. Yesterday, the case ended with a hung jury and a mistrial. Hardly the result either side wanted to see.
Disappointed. There are a lot of people in the law enforcement community especially that cared about this case.
Well, it's disappointing because we've always believed that he's innocent. We do have to respect the jury's decisions, and they worked very hard. They just couldn't come up with a solution. So we'll have to do it again.
For now, Allen remains in the Pierce County Jail. The Lakewood Police Union tells Fox 13 News they are disappointed with the outcome of the case. They are encouraged that yet another retrial is expected to start in January. And as for the next court date, that's even sooner. A hearing is set for December 16th to determine an exact date for the new trial. Live in the newsroom, Dan Griffin, Fox 13 News.
So in his second trial, the jury still could not deliver a verdict. And did you know that the government can keep retrying a defendant as many times as they want? So what do you think? Is the third time a charm for the defendant or the prosecutor? Well, let's find out, because this is something that happens in a lot of trials, and you'll find out why in a minute.
The man accused of being the getaway driver after 4 Lakewood police officers were shot and killed at a coffee shop in 2009 has pleaded guilty. Darcus Allen pleaded guilty to conspiracy to commit murder. The Pierce County Prosecutor's Office says he will soon be released after 13 years in custody.
So after so many years, in 2023, instead of going to trial, he decided to plead guilty. He had been in custody for so long that he thought it's not worth going through another trial. So he pled guilty, and of course they gave him time served. So that's another outcome that sometimes happens. Defendants, just can't go through it anymore. Next up is Ryan Widmer. In Cincinnati, he was accused of drowning his wife in the bathtub. Let's have a listen to the outcome of his first trial.
Ryan Widmer, Sarah Stewart, 2 young professionals brought together on a blind date. Soon after, Ryan and Sarah bought a house in Hamilton Township. Wedding invitations followed.
He was just as happy as happier than I've ever seen him with her.
In April of 2008, the two said their I do's.
They had everything to live for.
Then, just 114 days after they vowed till death do us part, that day came.
She hadn't been feeling well all day, and she decided that she would go up to take a bath.
8 months after Sarah's death, the trial. By that time, for reasons they wouldn't discuss, support from Sarah's family had faded. The circumstantial evidence included a sleep expert who said it was impossible to fall asleep in a bathtub and drown. Friends say Sarah would fall asleep all the time, at family functions, during her lunch breaks, and even Bengals games. The defense argued Sarah may have had an underlying health condition. Bruises on her scalp and neck? Resuscitation efforts, the defense says. As for Sarah's wet head and dry body, the body, Ryan's attorney says, dries quicker than hair. But could it have dried in the 6.5 minutes between the 911 call and the time police arrived? After 23 hours of deliberations, jurors reached a verdict.
Verdict on count 1, aggravated murder. We, the jury in this case, duly impaneled and sworn and affirmed, find the defendant, Ryan K. Widmer, is not guilty of aggravated murder.
At first, relief from Ryan's supporters, but it didn't last.
We, the jury in this case, duly impaneled and sworn and affirmed, find the defendant, Ryan K. Widmer, is guilty of the lesser included offense of murder.
I love my wife. I did not hurt her. I was never given a chance. The day after she passes away, they charged me with murder.
Ryan Widmer was sentenced to 15 years to life. Then a twist. A juror notified the defense that other jurors conducted home experiments to see how long it took a body to dry. 4 months after Ryan's conviction, the judge ruled Ryan deserved a new trial, citing juror misconduct. Now Ryan will be retried with a new defense team. Jury selection is scheduled to get underway on Monday. The not guilty verdict on the aggravated murder charge still stands, and prosecutors can only retry him on 1 count of murder. Karen Johnson, News 5.
So, what happened in the second trial? Let's have a listen, because I think there are some similarities with the Karen Reed case.
Just in the last 2 or 3 minutes, Judge Neil Bronson declared this a hung jury. He just dismissed the jurors. So what happens now? That has been the question all day long. There have been numerous defense attorneys who've been here following the case. I've been asking what happens if it's a hung jury. And from what I understand, there are several things that can happen. For one, it can be a whole new trial. It's up to the prosecution whether they want to retry this case. And if they decide to do so, then we'll have to start all over here. Also, though, most likely the defense attorneys in this case will file for a Rule 29, which means basically they're saying there's not enough evidence. Please just throw out the charges and dismiss the case completely. And Judge Neil Bronson does have the authority to do that. He can do that. But whether he will, whether he won't, we don't know at this point. I believe he has 2 weeks to decide that if the defense attorneys do indeed file for Rule 29, which they most likely will. But right now, just in the last few moments, Ryan Widmer, his family, all of his supporters who have been here all along just learned that this is a hung jury. Reporting live in Lebanon, Karen Johnson, News 5.
Karen, what was the reaction in the courtroom? This has been a long process. This is the second trial now. What was the reaction from both sides, if both were there?
Well, you know what, Sherry, I was literally walking out here to do this live shot, so I couldn't be in the courtroom. But I can tell you, if you want to take a look right now, they are all walking out. This is an emotional day. You can see reporters, photographers running out. That's Ryan's family. That's his father up at the front. That's Ryan Widmer actually leading the pack. You could see dozens of supporters behind him. I can't really see their reaction. We do have Terry Daniels, one of my colleagues, that is right on top of it. I see him right now. So we will bring you the reaction in the next few minutes. Hopefully by 5:30 we can get this on the air and tell you the reaction. I can tell you, though, what it's been like all day. I spent some time talking to his father earlier today, who's been here all day, and they were just nervous. They didn't know what to think. Anxious. I know his mother, Jill Widmer, she has spent a lot of Friday and this morning at home, I'm told, because she just couldn't take not knowing. They said that was the worst part. But you can see from them walking out, I bet you it was a very, very emotional decision. And hopefully within the next hour, we'll find out what may be the next step.
One more question, Karen. Do you have any breakdown of what the polling of the jury was? How many were undecided, or what the split was?
You know what, Cherie? In some court cases, the judge will tell you. In this one, I even asked his attorneys. They said they didn't know. They didn't know if it was just 2 people holding out, or we just don't know at this point. That's something, though, that could be released now that it is a hung jury, but it's up to the judge. Basically, everything is up to the judge at this point.
All right, Karen, I know it's all unfolding right now. We'll be checking back at 5:30 and again at 6 o'clock. Karen Johnson live. Thank you.
So, what happened in Ryan Widmer's third trial? On the 15th of February 2011, he was found guilty and sentenced to 15 years in prison. He filed several errors the court made, and here's some of the similarities with the Karen Read case: that the court erred in failing to properly instruct the jury on the lesser included offenses. Sound familiar? I think this is why the jury was unable to understand the judge's instructions on the Karen Read's case with the verdict slips, and you can see my video on this. He tried several appeals, and the Court of Appeals affirmed the conviction and sentence. So he had several more appeals. Here's another example of something that he appealed: the admissibility of an expert witness. Because the defense did not seek to voir dire the expert's qualifications, he was admitted without objection. And because the trial judge has discretion to allow an expert, well, the appeals court felt this was not an abuse of discretion where the testimony is relevant. Basically, he lost all his appeals, and due process is only violated when a jury cannot draw inferences from the evidence. And do you remember the news reporter saying that his defense would appeal, that there was sufficient evidence? Well, after viewing the evidence, the appeal court decided that, the evidence is always looked at most favorable to the prosecution. Any rational trier of fact could have found elements of the crime beyond a reasonable doubt. And here's an example the appeal court gave. They said that Ryan Widmer told the 911 dispatcher that he found his wife with her face down in the tub. And then he told the nurse in the emergency room he found her face up in the tub. So they said this was an example of testimony conflicting statements to various individuals. And we have a similar thing that happened with the Karen Read trial, which I did a video on. So when various people said, Karen Read said, I hit him, this would be an example of evidence that favors the prosecution's case. So, technically the prosecution could have enough to go forward. And this leads nicely into Keep It Simple, Stupid K.I.S.S. A study by the National Center for State and Courts has indicated that 6% of felony cases disposed by a jury are hung if the case is more complicated, and this complexity is underestimated by both the attorneys and judges, especially if the evidence is open to more than one interpretation. This case has caught worldwide attention, and my playlists go through a lot of the issues that I found with the trial. So having a retrial, I think, will be difficult for the Commonwealth given the evidence they produced. Although there are people that think Karen Read is responsible for her boyfriend's demise, I just don't think the evidence is there. Well, I hope I haven't overcomplicated things in this video for you, and you've got three potential outcomes that I thought were, kind of like main outcomes that could come out of a retrial. And we've also got, the case that I think is similar to the Karen Read case and how appeals really didn't work. What's going to likely happen? Who knows? We'll see. But anyway, what's your comments? let me know your thoughts. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.